Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today's topic for discussion would be on enforcement of arbitral awards, foreign and domestic. And joining us today on the Virtual Amicus is someone who needs absolutely no formal introduction in the field of arbitration. She's one of the most sought after lawyers in arbitration. We are in conversation with Sonali Mathur ma'am. And just to give you all a brief introduction about our amicus for today's session, she was a former partner in the dispute resolution practice at AZB and Partners Mumbai. She pursued a master's degree from Columbia University School of Law, New York. She's also an alumni of Government Law College, Mumbai, and she's joining us from California. She has advised and represented clients in several domestic and international arbitrations, ad hoc and institutional, involving a large number of complex commercial and contractual issues across various sectors such as insurance, projects, etc. Her work highlights include a landmark decision of the Supreme Court distinguishing between seat and venue of arbitration and enforcement of one of the largest claims awarded in international treaty arbitration against a state. She is a member of Young SIAC Committee and the International Council for Commercial Arbitration. She's been recognized by Chambers Global 2021 to 2023 and Chambers Asia Pacific 21 to 23, and also recommended by Legal 500 Asia Pacific 21 to 23 in dispute resolution litigation and dispute resolution arbitration. She was also a part-time professor at Government Law College Mumbai, teaching arbitration and contract law. Thank you so much, ma'am, for taking out time and for doing and saying yes for a session on our channel. Anything that you wish to say before we start with our Q&A?
Thank you. Thank you so much, Jay, for having me on your platform. And I think it's a great endeavor that you're doing, in your spare time to try and teach a lot of basic concepts to students and young lawyers. So I certainly am very happy to be a part of this endeavor. Thank you.
Thank you for all the kind words, ma'am. Now let's quickly start with our Q&A segment, and I'm really very excited and looking forward to it. So, ma'am, question number one: what is the difference between place, venue, and seat of arbitration?
Okay, that certainly is one of the most complex questions that has also vexed the judiciary in our country for several years. And I think before just diving into that, I wanted to give a background into just the structure of the Arbitration Act and the background as to how the Arbitration Act came about. As I'm sure all the viewers would know that the main act in India which deals with arbitration is the Arbitration and Conciliation Act 1996. Prior to that act, there were three other acts, which was the Arbitration Protocol and Convention Act of 1937, the Indian Arbitration Act of 1940, and the Foreign Awards Recognition and Enforcement Act of 1961, which were in play. While the Arbitration Act of 1940 dealt with the law relating to arbitration in India, the other two acts, 1937 and 61, really spoke about enforcement of foreign awards. And all of these three acts then got consolidated in the 1996 Act. What is very important to note is that the 96 Act is divided into two main parts which deal with arbitration. The third part deals with conciliation, so we won't touch upon that. But part one and part two, which is discussed in numerous judgments and how the two interplay, is very important to understand when you want to understand the concept of what is seat, what is venue, what is a domestic award, what is a foreign award, what is an international commercial arbitration. So I'll just spend a few minutes discussing the main structure of the act and how that is played out, and then I'll answer your question in more detail. So part one of the Arbitration Act, if you open the act, and I feel like every law student and young lawyer should be very well acquainted with the bare provisions of the act. If you open the act to section 2.2, you will see that that falls within part one, which says that that part will apply where the place of arbitration is in India. Now, it's very important to note the word used here, place. And any award that is generated from an arbitration which is seated in India, where the place of arbitration is in India, is then governed by part one of the Arbitration Act. And any award which is seated outside India or which the place of arbitration is outside India, is a foreign award, which is then brought into India for enforcement under Part 2 of the Arbitration Act. When you actually look at the index of the Act, you will realize that the provisions in Part 1 are way more. It deals with a lot of provisions, right from the appointment of an arbitrator to the number of arbitrators to interim proceedings, as well as to how the arbitration will be conducted and the challenge mechanism and enforcement mechanism. Whereas Part 2 is much smaller. It only talks of enforcement, because what you're really trying to do is that the award is passed outside the country, you're bringing it in for the purposes of enforcement. So remember one thing, that Part 1 really deals with two different kinds of arbitrations. I'll deal with that in a minute. But just to highlight that quickly, one is a pure domestic arbitration where the identity of the parties are entirely Indian. And the other is an international commercial arbitration seated in India, where the identity of one of the parties is foreign. So there is a common misconception amongst a lot of people that a lot of students I've spoken to, where they feel like Part 1 is domestic, Part 2 is foreign. That is incorrect. Part 1 can also deal with an element, a foreign element, which is a party that is foreign. Okay, so now coming back to your question of what is seat, what is venue, what is place, because I showed you 2.2 of the Arbitration Act, which talks of a part will apply where the place of arbitration is in India. Now, place is synonymous with seat in Section 2.2 of the Arbitration Act. Seat is really the center of gravity of an arbitration. Okay. Arbitration, by its very nature, is a private contractual forum. Parties, by contract, decide that they are going to have an arbitrator decide the dispute as opposed to a judge. And therefore, they, by contract, decide the entire framework of arbitration. However, you cannot have that arbitration float in a void space. It has to be tethered to some country's court system for numerous reasons, which I'll explain. But it is important that one country has, or the court of one country has supervisory jurisdiction over an arbitration, which otherwise is entirely a private mechanism for adjudication of disputes. So that really is the seat of arbitration. Okay, that one country. And also importantly, there can only be one seat of an arbitration, and it is decided by the parties at the time of entering into the arbitration agreement. So the time that you sign your contract, it is important to mention what the seat of the arbitration will be, because if you do not mention that, that can lead into a lot of litigation. And there have been a number of judgments, including one that I was involved in, which was Enercon, where the parties spent numerous years only trying to determine which is the seat. So the takeaway from all the litigation that has already happened in this country is that please be very clear when you're entering into a contract as to what the seat of the arbitration is, because only that country's courts will have supervisory jurisdiction over that arbitration clause or that arbitration. If your arbitration is seated in India, if it's domestic, then again it's important to mention the city. So courts in Mumbai or Mumbai shall be seat, or Delhi shall be seat. The minute you say that, means the courts of Mumbai or Delhi, whatever you have chosen, will be having complete jurisdiction over all aspects of that arbitration, including, say, a Section 9 application for interim reliefs, or even if you want to challenge the arbitration award later, you know that there is that one court that you will go to, and you will not waste time trying to go into the wrong courts. So that is the importance of selection of seat. Now, coming back to Part 1 and Part 2. Part 1 of the arbitration, like I told you, is a lengthier part of the Arbitration Act. And it deals with any arbitration where the parties have clearly chosen India as the seat. Okay. Or if it is any place within India, if it's purely domestic, then obviously Part 1 will automatically apply. You don't even have to make a provision for it. If it's a purely domestic arbitration, then you don't worry about it. Part 1's provisions, mandatory provisions will apply. Now, coming to the whole idea of the interplay between Part 1 and Part 2, there has been a lot of confusion in the past where, particularly in the context of interim reliefs, where courts were intermingling Part 1 and Part 2 in the sense they were applying provisions of Part 1 even to an arbitration which was, say, seated in London or seated in Singapore. Okay, and that gave rise to this decision, which I'm sure a lot of you would have known, was Bhatia International. Okay, this was in 2002, a wrong decision because it was ultimately reversed in a decision of the Supreme Court again 10 years later, which was BALCO, the Bharat Aluminium versus Kaiser Technology. I'm sure that is also, well known. But Bhatia International, in its in its attempt to give interim relief to one of the parties, which was in an arbitration that was seated in Paris, extended Section 9 to Part 2. Now, Section 9 is purely within the realm of Part 1. But they went ahead and they gave interim reliefs. And that line of judgment from Bhatia till BALCO from 2002 to 2012 is an incorrect line of judgments where the judges were interfering way more than they should have interfered in foreign seated arbitrations. It led to a lot of international criticism as well, that India has not really understood the idea of arbitrations and the hands-off approach that the judiciary should adopt. That came to be corrected in the BALCO decision in 2012, where they said Part 1 and Part 2 are completely separate. You cannot mix the two. Part 1 deals with the seat being in India. Part 2 deals with the seat being outside India. If a party has chosen Part 2, you cannot apply any provision of Part 1, okay, unless the parties have agreed. That was BALCO's decision. And interestingly, 2012, after that, there is a very important amendment that has been carried out in 2015, which is just below 2.2. There's a proviso that has been introduced just below 2.2, which says that the provisions of Section 9, 27, and 37, subsection 1 and 3, will apply to an international seated arbitration now, if the parties have agreed. Okay. So the reason they introduced this proviso was to try and rectify the issue that Bhatia had faced, which is to try and give some interim relief to a foreign seated arbitration from Part 1. So they have created this amendment now, and they said that even if the seat is outside the country, you will still have the benefit of Section 9, 27, and 37, unless the parties choose otherwise. Okay, so that is the legislative benefit that has been granted to foreign seated arbitrations, to say that your assets in India will still be protected. You can still come to an Indian court for Section 9 relief. Now, what is venue? Venue really is a place that the parties choose to have the arbitration meetings. It can change entirely during the course of the arbitration with the consent of the arbitrator as well as the parties. Okay, so the seat can never be changed unless in writing by the parties, but the venue can be changed. It can be the convenience of the parties. If you have an international arbitrator who's, say, seated in London, and if he decides that, okay, the next set of hearings we will have them in India, the parties can change the venue from London to India. That will not change the seat if the seat was otherwise London. Okay, so the mere fact of change of venue of the parties of the arbitration will not have an impact legally on that arbitration. But the change of a seat will impact the arbitration legally, because then the court which has supervisory jurisdiction changes. So that is the primary distinction between seat venue. Please note that the Arbitration Act does not use the word seat or venue. It uses the word place. And the meaning of place in 2.2 means seat. There is another place in section 20 where the word place of arbitration is used. And you will notice if you read section 20, it says the parties are free to agree on the place of arbitration. And 22, subsection 2, actually doesn't say the word venue, but it means venue, because it says the place shall be determined by the tribunal having regard to the circumstances of the case, including the convenience of the parties. So in section 20, subclause 2, the word really should have been venue, but the word used is place. So I feel the legislature did have an occasion to kind of correct this confusion in 2015, particularly when they were going through an overhaul of the entire act, and they should have just clarified the word seat and venue in the act. But nonetheless, the meaning of these words is there in section 2.2 and in section 20. Okay. Now, I had touched upon what part 1 dealt with earlier. I just want to explain that with reference to one more definition that I think everyone should know about, is the definition of international commercial arbitration, because there is a lot of confusion amongst parties and sometimes students who feel like part 1 does not deal with international commercial arbitration. That is not true. 2F of the Act defines an ICA to mean basically any dispute where at least one of the parties is a body corporate that is incorporated in a country outside India, or an association or body of individuals whose central management and control is exercised in any country other than India. So read the definition of 2F, and you will see that the only thing that distinguishes a pure domestic arbitration and an international commercial arbitration seated in India is the identity of the parties. The minute one of the parties is a foreign party, it becomes an ICA. The minute both the parties are domestic parties, it's a pure domestic arbitration. And both these types of arbitrations can be seated in India. Because the choosing of a seat has nothing to do with whether the arbitration is domestic or an ICA or a foreign. In the sense, it doesn't have to do anything with the identity of the parties. I hope I'm making myself clear, and this is a very important sort of fundamental concept that all students should understand, is that part 1 applies to pure domestic arbitrations, and part 1 also applies to international commercial arbitrations where one of the parties is a foreign party seated in India. Now, the reason why I'm stressing on this distinction is also to kind of give you a bit of a foundational knowledge when we deal with section 34, which deals with challenge to an arbitration award. You will see there are 2 different standards of challenge. So one standard applies to pure international commercial arbitrations where one of the parties is foreign. And the other standard is an extra standard that has been provided, which applies to pure domestic as well. So that's why the distinction is important to note. In pure foreign arbitrations where you have where you can have 2 parties who can now be 2 Indians choosing a foreign seat. There is a recent decision of the Supreme Court in PASL Wind Solutions versus GE Power Conversion. I think it's a 2021 decision where the Supreme Court has now clarified that 2 Indian parties can also choose a foreign seat. Okay, so there is no problem there. That award that will say come out of Singapore will then be brought in to enforce for enforcement in India through Part 2 of the Arbitration Act, which we'll also discuss. So I hope I'm making myself clear on this, that Part 1 and Part 2 are not to be commingled, they're not to be mixed. There is a provision in the proviso to 2.2 where 9, 27 and 37 from Part 1 can apply to Part 2 if the parties don't agree otherwise. Otherwise, it is applicable, but the parties don't have to contract out of it. And then you have the two different types of arbitrations within Part 1.
Very well. I'm now going ahead with our next question. Ma'am, if you could briefly explain the difference between an ad hoc arbitration, which is obviously a court-appointed arbitrator under Section 11, and an institutional arbitration.
Okay, so the distinction between the two really comes about from how the arbitration clause is drafted. So again, this depends on the agreement of the parties, typically formed when the contract is signed. If the parties have agreed to an ad hoc procedure under the Indian Arbitration Act, which basically means that the clause will say that the parties shall appoint a sole arbitrator, or the party shall appoint a panel of 3 arbitrators to be arbitration shall be governed by the Indian Arbitration Act 96. That's an ad hoc arbitration. No institution is involved because no institution is designated in the clause. That has been the traditional form of arbitration in India, since many years. And there has been a lot of criticism about the time, the delays that are caused, the expenditure that the parties have to incur because of such delays. Because there is no, at least prior to the 2015 amendment, there was no sort of oversight on how the arbitration was being conducted. And it could stretch on for years and years, which is why in the 2015 amendment, there was a provision that was introduced to put a timeline on the arbitration, which was a timeline on the ad hoc procedure, right, of ad hoc arbitrations. Now, institutional arbitrations is something that has institutions have come up, in the last, say, 10 to 15 years. And now the trend is really for parties to agree to the rules of a well-established institution, which will govern the entire running of the arbitration, okay, in a more systematic and a more efficient manner. So, for example, you have the Singapore International Arbitration Center, SIAC, which is pretty well known, although it has its headquarters in Singapore. Parties in India can also apply the SIAC rules to an arbitration that is seated entirely in India, because then SIAC will run that arbitration through Singapore. But nonetheless, the rules which are well established will govern that arbitration. You have other institutions like the ICC as well. You have HKIAC. These are international. You have LCIA, which is the London Court of International Arbitration. So there are numerous institutions with very, very well-established and well-regarded rules, which can then be adopted into your clause. The mere mention of that institution means you've automatically incorporated the rules of that institution into your clause. So that really helps in the manner in which your arbitration is conducted. In India as well, you have some Indian institutions with very, very good rules, which are at par with the international institutions. You have the MCIA, which is, in Mumbai. Recently, you would have known the Hyderabad Center for Arbitration has also opened up. And that is also, another Indian institution. Delhi has an institution as well. So the point is that if you have a purely domestic arbitration, I know that a lot of parties do tend to go for the Indian institutions. Sometimes parties insist on using international rules like SIAC, ICC, or LCIA into their clauses. And these rules harmoniously work with the Indian Arbitration Act. So it is not to say that you can ignore the International Arbitration Act completely, or you can only follow the rules. It's not like that. There are certain provisions, which are non-mandatory in the Indian Arbitration Act in Part 1, where the rules supplement. Say, for example, your timelines of how your statement of claim should be filed, or when your response should be filed. These timelines are not mandatory in the act, so you can supplement them from the rules. For example, appointment of an emergency arbitrator. There's a whole process in most of these rules that if you want very quick relief, one option is Section 9, where you can run to an Indian court for reliefs, but the rules also provide that within, say 48 hours, you can apply to the registrar or the authority within the institution, and they can appoint an arbitrator, which can then render a decision very quickly within 10 days, 14 days. And that is an emergency arbitrator's award. Now, you don't have that provision in the act, but the minute you choose the rules, you have incorporated those provisions in your arbitration. Only benefits from having that process incorporated. And there is a very recent decision of the Supreme Court in the case of Amazon versus Future Retail, where this whole issue arose that in an arbitration that is run by the SIAC institution, does an emergency arbitrators award have any sanctity? Can it be enforced? And very importantly to note there is that Amazon, that decision, the seat was India. Okay. In that case, the venue was Singapore. So it was in that sense a Part 1 arbitration. And the courts then, discussed the provisions of an emergency arbitrators award under section, and they discussed it under section 17 of the Act, which is interim orders by a tribunal. And they said it is enforceable. So people again think that Amazon was a foreign arbitration. It was not. The seat was in India. So in any event, the court has said that an emergency arbitrator's order, at least for arbitrations that are seated in India, is enforceable. So this is essentially, what ad hoc and institution really means is that the world really is pushing towards a trend of having institutional arbitrations, being incorporated in clauses. So parties, when they're entering into the contract, need to be conscious of this fact, because there is, in that sense, an oversight on that arbitration, which immensely helps with the time, the cost, and how efficiently the process is run.
Very well, ma'am. Now, going ahead with our next question, if in a nutshell you could explain what kind of arbitrations are classified as international commercial arbitrations.
So international commercial arbitrations, like I told you, are essentially an arbitration where one of the parties is a foreign party. Okay. It really doesn't have that much of a distinction in terms of the core merit. You can have the same dispute, same identical facts. Okay. But if two parties are Indian, it becomes domestic. If one of the parties is foreign, it becomes an international commercial arbitration. The key factor really is to decide what is the seat of arbitration. If your seat is India, okay, you can have a pure domestic arbitration in India, you can have an ICA in India. The minute you say seat is foreign, then you can have two Indian parties also in that foreign seat, or you can have one Indian and one international party in the foreign seat.
Now, ma'am, if you could explain the grounds for challenging an arbitral award.
Okay, sure. So the relevant provision for challenge under Part 1 is Section 34. And you have to remember one thing, that the challenge mechanism is laid out in the jurisdiction where the seat is. That's why I told you earlier that part 1 does have a more exhaustive set of provisions, because where the seat is in India, the challenge will lie in India. If the seat is outside, say the seat was London, the London Arbitration Act will have its own provision to challenge. Okay. Now, looking at section 34, there are few grounds on which you can challenge an arbitration award. Please don't confuse the word appeal with challenge, because you cannot really appeal an arbitration award. An arbitration award is final and binding, and that is also provided for clearly in the Act. But obviously, like I told you, you cannot have an arbitration that is hanging in space without it being attached to some supervisory jurisdiction of some court. So therefore, section 34, which is in that sense pretty internationally standard, and it is modeled on the model law, as well as all the New York Convention countries also have similar grounds, basically will give you a number of grounds on which you can challenge that award. And you have to, when you file your petition for challenge, fix your arbitration within those grounds, your challenge within those grounds. Now, I don't want to sort of get into all the grounds, because some of them are pretty self-explanatory, but to say that the arbitration agreement was not valid under the law to which the parties have subjected it, or the law for the time being in force, or the party was not given proper notice, or the award deals with a dispute that was not contemplated by the parties, or the composition of the tribunal is not something in accordance with the agreement. These are fairly self-explanatory grounds. I think what I do want to focus our limited time on are certain grounds which have been the subject matter of a number of judicial, discussions and judgments. So one important ground is that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force. Now, this comes up very often, because parties are fighting on the arbitrability of a dispute. So I just want to take a limited amount of time to discuss what really arbitrability of a dispute means. And there have been numerous decisions on this point, starting from the famous decision of Booz Allen and Hamilton versus SBI Home Finance, where the court discussed the concept of arbitrability and basically spoke about in rem proceedings and in personam proceedings. Okay, and they have kind of classified some disputes which are not arbitrable, like matrimonial disputes, or which are, say, criminal disputes, guardianship matters, insolvency, testamentary matters. So these are some disputes which in Booz Allen were like in rem proceedings, and they cannot be arbitrated in a private contractual forum. Then there was a huge line of decisions which basically tried to talk about arbitrability of fraud. Now, we have limited time, so I don't want to get into too much detail about fraud. But the bottom line is that it started out with the Radhakrishnan judgment, where the court was strictly of the opinion that the minute you mention fraud or serious malpractices in a particular dispute, then only the court should be the correct forum to decide that dispute, and that dispute should not be arbitrated in a private tribunal. So they basically said that fraud and collusion or any kind of criminal related allegations or claims will not be arbitrated. But from that position, the court has moved a lot to the other side. And now, like, there were decisions of Swiss timing and Ayasami and Rashid Raza. So these are important decisions which have now basically said that fraud can be arbitrated. So there are certain tests that the court has laid down to say that, is it a simple allegation of fraud, or does fraud permeate the entire contract, rendering the arbitration agreement void? So that is one test. Or whether the allegation of fraud touches upon the internal affairs of the parties, having an implication on public domain. So, these are like two tests which were laid down from the Ayasami decision. And again, there have been numerous decisions which I don't have time to get into in detail. But I think if you read the Arbitral decision ultimately, which I think was, again, a landmark decision on this issue, they have finally harmonized the jurisprudence on this issue and have said that serious allegations of fraud will only arise when the arbitration agreement ceases to exist because it is vitiated by fraud. And the allegations are made against the state or its instrumentalities, giving rise to questions of public law, as opposed to questions relating to private and contractual relationship between parties. So in those cases, they said it is not arbitrable, but otherwise, all other cases of fraud, except the ones which have those serious allegations, are arbitrable. Okay, so again, this has sort of kind of settled the whole debate on whether fraud can be arbitrated or not. One other important decision that I do want to sort of mention is the case of Vidya Drolia, which again is a recent decision of the Supreme Court, where the court formulated a fourfold test to determine when the subject matter of a dispute is arbitrable or not. Okay, and again, one of the tests was when the cause of action in subject matter relates to actions in rem that do not pertain to the subordinate rights in personam. So it's again in rem proceedings, or if it affects third party rights, or if there is an inalienable sovereign function involved. Or the fourth test is that the subject matter is expressly or by necessary implication non-arbitrable as per a mandatory statute. So in Vidya Drolia, they were testing whether tenancy disputes are arbitrable or not. And the courts basically said that they are arbitrable because they are not really governed by any mandatory statute, and it would depend on the agreement of the parties. So under the Transfer of Property Act, which is discussed in that judgment, they said that it can be referred to arbitration as well, landlord-tenant disputes. This was the Vidya Drolia decision. Now, this decision is definitely an important one to read, and I would certainly request, I think, the students to take time to read this decision as well, because this will kind of be one of the landmark decisions whenever you're dealing with a decision or the issue of arbitrability of an award. The one other point that a side point that I do want to mention is that this decision, although in the context of tenancy laws, also kind of made some observations in relation to a different topic relating to debt recovery laws, okay, which has raised a bit of a controversy, at least academically, and I'm pretty sure it will be subject to a separate independent challenge. But they dealt with the Recovery of Debts and Bankruptcy Act 93, which is the DRT Act, colloquially, and the Sarfazi Act. And they basically said that these acts give jurisdiction to the DRT, the tribunal that is specially framed under these laws, and they cannot, disputes under these statutes cannot be arbitrated. So this has kind of created a flutter in the banking space after Vidya Drolia came out, where a lot of NBFCs, which have arbitration agreements, have sort of been discussing what to do, and it expressly overruled a Delhi High Court judgment in HDFC versus Satpal Singh Bakshi, which had said that these debt recovery disputes are in personam disputes. So that has been overruled. So this is an interesting space that you should watch out for. And there's definitely more jurisprudence that will be developed specifically to the banking sector on what is arbitrable and what is not arbitrable. So with that, I think I can move to the next topic. But I think one additional thing that I do want to mention, at least from my practice that I have seen, is that there is a huge number of cases that arise from pure contractual disputes, and they somehow end up in the NCLT. And then you will find that there is a bit of a tussle between the NCLT and the arbitration tribunal into deciding whether the dispute is arbitrable or not arbitrable. So typically what happens is that, say, one of the parties, say the dispute arises out of and it arises out of a shareholders agreement, okay, which are pure contractual rights, and one of the parties sort of takes the dispute under an oppression mismanagement petition to an NCLT. Now, the party that has initiated the arbitration will then try to file an anti-suit injunction, try to restrain the other party from going to the NCLT, whereas the party in the NCLT will say that this is an in rem proceeding. It is not arbitrable. The dispute is different from the arbitration. But this is a typical sort of structure that we have seen in many cases. And very recently, there is an interesting fight that has been going on in Singapore and India, actually. But the Singapore Court of Appeals in 2023 has issued an important decision in Anupam Mittal versus Westbridge Ventures. Okay. Now, in this case, it's the typical scenario that I just described, where I think the Indian promoter has started an oppression mismanagement action in the NCLT. And I think the foreign party is saying that it is entirely covered by arbitration, the dispute. So therefore, they sought an anti-suit injunction. The interesting issue that arose here is that what law should govern this issue of arbitrability? Now, remember one thing, that whenever you have an international arbitration, you can have a number of laws in place, particularly if in a foreign seat. So there are typically 3 laws that are played out in every, international arbitration. So one is your law governing the substantive contract. So you can have Indian law shall govern the contract. So the substantive rights in the contract will be Indian law. Then suppose you have a foreign seat. Say the arbitration shall be conducted in Singapore. Now, Singapore law becomes the law governing the procedure of the arbitration, which is called the curial law. Okay. So all matters in relation to how the arbitration will be conducted will be as per Singapore law. Only by choosing Singapore as the seat in your clause, automatically Singapore law comes into place. So you have an Indian law, which is governing the substance of the contract, and you have Singapore law, which is the law of the seat. The confusion arises with the third law, which is law governing the agreement to arbitrate, which is lex arbitrae. Now, as you all know, the arbitration agreement is like a living creature which exists independent of your main contract, right? So you have the law governing the substantive law, right, which is your law number 1, as they say. Law number 2 is this law which governs the agreement. Now, typically, a lot of times, it should be the same law. Keeps things simple, right? Sometimes parties are now being cautious and even mentioning it in their clauses, that the law governing the contract as well as the arbitration agreement shall be Indian law. So they have chosen law number 1 and law number 2 as Indian law. And then law number 3 is your law governing the seat, curial law, which can be separate, because that only determines the procedure of the arbitration itself. It's more procedural in nature. Okay. But arbitrability of a dispute, arbitrability, or whether the dispute is arbitrable or not, is now governed by the law of the arbitration agreement as per the Westbridge decision. And in that decision, they held that Singapore was the law of the arbitration agreement, which is your law number 2, because there the parties had not expressly chosen law number 2. If you look at a lot of older clauses, you'll see people typically choose law number 1 and law number 3. They choose the governing law of the contract, they choose the seat, but they don't put a provision in the clause specifically saying what is the law governing the arbitration agreement. So there are a lot of decisions that have now developed a lot of tests, like what is the real and substantial connection, the closest connection test. And there are a number of tests that courts have sort of, in England and in Singapore and in India, they've tried to develop, looking at the facts and circumstances of the entire case to try and see what really was the party's intention as regards the law of the arbitration agreement, which is law number 2. So like a safe tip is that if you're drafting a clause, please mention it. So you should mention all the 3 laws. But if it's not mentioned, then clearly there is jurisprudence also that's coming up, which kind of is developing tests based on the facts and the intention of the parties. So the Westbridge decision granted an anti-suit against the Indian promoter, okay? And they stopped the NCLT proceedings because they said, as per the law of the arbitration agreement, which in that case was interpreted to be Singapore law, the oppression mismanagement proceedings could also be arbitrated. In India, they can't be. You see, Indian law categorically would say an oppression mismanagement proceeding is a in rem proceeding, which only NCLT has jurisdiction over, because the Vidya Drolia test also will take you back to that conclusion. But under Singapore law, it was. So when that award finally gets passed in Singapore and brought to India for enforcement in the future, please do watch the space and see that there could be a challenge again on arbitrability of that dispute and whether it was arbitrable or not. So they can also challenge it when they bring it for enforcement. But it will be not under Section 34, it will be under 48, which is Part 2 of the Arbitration Act, because it's a foreign award. But I'll deal with 48 too. So I think this is essentially one of the important grounds to look at as far as a challenge under 34 is concerned. The same ground is also under 48. So when you look at 48, you'll see the same ground is mentioned there. The next important ground is the arbitral award is in conflict with the public policy of India. Now, public policy, again, is a highly vexed term because it's been subject to a lot of judicial interpretation, right from the Renu Sagar decision of 94 till, there was a Saw Pipes, ONGC versus Saw Pipes decision in 2003. So now, coming to the initial Renu Sagar decision, there were like 3 prongs really that they tried to explain public policy on. Okay, they said that an award would be contrary to public policy if the enforcement is contrary to the fundamental policy of Indian law, the interest of India, or justice or morality. Okay, now very interestingly, in the 2015 amendment, these 3 Renu Sagar principles have been categorically enshrined in the explanation. So now if you look at the Act, it says the arbitral award is in conflict with public policy, and below it says, for the avoidance of any doubt, public policy means if an award is induced by fraud or corruption or in violation of Section 75 or 81, 75, 81 deal with conciliation proceedings. Okay, so it basically means that if anything is discussed in a conciliation proceeding and you use it later in an award, that's in violation of the confidentiality provisions there. So that is pretty self-explanatory. Then it is in contravention of the fundamental policy of Indian law or in conflict with the most basic notions of justice or morality. There's a second explanation which says the test as to whether there's a contravention with the fundamental policy of Indian law shall not entail a review of the merits of the dispute categorically inserted to try and push the judges back from taking that challenge and converting it into an appeal. It is not an appeal. And I think judges also have to realize that when they are looking at an award, they may come to a different conclusion on facts from what the arbitrators decided, possibly. That still doesn't mean that the arbitrators were wrong unless there was something absolutely perverse, that it was impossible for them to have come to that conclusion. Only in that limited scenario will the award be set aside. But just because an alternate interpretation is possible and the judge feels his interpretation is right, does not mean that the award will be set aside. So I think legislatively also there was this caveat inserted that please do not review the merits of the dispute as if you are sitting in appeal. We were trying to push the judges back, which is again in line with the spirit of how arbitration should be conducted internationally, the whole hands-off approach by courts. And that was, I think, important also to educate the Indian judiciary to not be overzealous in their review on the challenge proceedings. Now, very, very interestingly, there is a provision 2A that is added. Remember, I think at the start of my talk, I told you that there are two standards for deciding a challenge proceeding, depending on the nationality of the parties involved. So if it is a purely domestic arbitration with two Indians, then there is an additional ground that the award can be vitiated by patent illegality appearing on the face of the award. This ground is not available in an international commercial arbitration that is seated in, where one of the parties is foreign. Now, if you ask me the logic of this provision, I've been trying to understand that myself for the last 8 years, and I don't understand it. I do have a sense of why this was introduced, but my very personal opinion and humble opinion, I don't think this is a correct sort of standard to have, because you can have the very same dispute and the same facts. The identity of the nationality of the parties should not determine two different standards of challenge or the grounds for challenge. But that is how the Act is structured today, that you have patent illegality appearing on the face of the award as an additional ground that is available only in purely domestic arbitrations. Now, historically, we've seen that a lot of awards have patent illegality just thrown in, okay? It's the easiest thing to allege. Now, what really is patent illegality? ONGC versus Saw Pipes is a decision that really introduced the concept and introduced this as the fourth ground, in addition to the three that Renu Sagar had mentioned. Basically, saying that, if it's against the provisions of the Act or it's conflicting with any statutory provisions or the terms of the contract, then you have ONGC versus Western Gecko also, which kind of added on to say that, the illegality must go to the root of the matter and not just any trivial sort of, objection to it. Now, would depend on the facts and circumstances of the case to determine whether patent illegality is attracted or not. But this is certainly one of the most obvious, grounds that any domestic award is now challenged on. Now, again, there's a proviso that's mentioned below, which says an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. Again, this is a way of pushing back judges to say that, look, if there is an alternative approach that is permissible, or an interpretation that you think is right, is not good enough reasons to set aside an award. So, Jess, sorry, I don't know if you're running out of time here.
No, ma'am, you can go ahead. No issues. Yeah.
Okay. Now, these are essentially the main sort of grounds that are available to challenge an award. I just want to touch upon a little bit on the process as well. So the Act provides for a timeline of, say, 3 months after an award is passed for the losing party to file a challenge. And in that time, the successful party cannot enforce the award. Okay, that 3 months period can also be extended by a further period of 30 days if the court decides that there was sufficient cause for not making the application within the initial 3 months. But once earlier, prior to 2015, once you would file this petition for enforcement, the law was that there was an automatic stay. And this was highly abused as well, because the losing party would just file a petition under 34 and it would keep languishing in court for several years, and the successful party would not really see any money even though they had won the award. So that was changed in 2015, where now it's very categorical in section 36 subclause 2, that when an application has been made, the award will not be unenforceable unless the court grants an order of stay. And usually this stay order is conditional upon the unsuccessful party providing some security or making some payment into court. So now you have to put your money where the challenge is, and there is also then incentive for the unsuccessful party to push the challenge proceeding to get concluded faster. So this was a very important amendment that was made in 2015. Just one aside is that if the students want to read why the amendments were made in 2015, the 246 Law Commission report is a very exhaustive document which is available online, where you can actually read about what issues existed prior to 2015 and then what was the suggestions made, and then you can look at the actual amendment to see how the suggestions were implemented, and some were not. But it's certainly an important document to consider whenever you're trying to understand why a particular change was made. So this is an important amendment, like I mentioned, that there is no automatic stay now, except for one exception which was introduced in 2021. In 2021, the court the statute inserted a proviso that if the court is satisfied on a prima facie basis that the arbitration agreement or contract, which is the basis of the award, or the making of the award was vitiated or induced by fraud or corruption, then an unconditional stay can be granted pending the challenge under Section 34. So only in that limited scenario an unconditional stay can be granted. But otherwise, the norm is that if you have challenged a petition under 30, if you've challenged an award under 34, then you have to deposit some money. It has to be a conditional stay. There is no automatic stay.
Very well, ma'am. You're indeed a repository of knowledge. Now, going ahead with our next question, ma'am, what are the requirements for enforcement of foreign arbitral awards in India?
Right. So this sort of takes me to part 2 of the Arbitration Act, which I have mentioned before. Now, part 2, like I told you, is a much smaller part. If you look at it, there are just 5-6 important sections. Okay, and it really talks about an award that is passed in a foreign country, and it's already in that sense. Suppose it's passed in Singapore. It is possible that a challenge proceeding could have been filed in the Singapore High Court. Okay, and once that has been settled, which basically means that the award is not set aside, the challenge is unsuccessful, you are entitled to enforce it anywhere in the world. But you obviously go after assets. So you will then see if the assets are in India, and you will then try to bring that foreign award into India. Now, in order to do that, you need to look at Section 44. Okay, now 44 is an important section to decide what is, the requirement for bringing it into India. Now, remember one thing, that there were two important conventions that a number of countries in the world are parties to. One was an earlier convention known as the Geneva Convention, which is the Convention on the Execution of Foreign Arbitral Awards 1927. And the more important one, the more widespread one really, is the 1958 Convention on the Recognition and Enforcement of Foreign Arbitral Awards, known as the New York Convention. So chapter 1 of part 2, when you deal with 44, 45, 46, 48, these are provisions dealing with the New York Convention. Okay, you have the same provisions in the act dealing with the Geneva Convention also. So one check is that you have to do is look at the country that the award was passed in, which basically means which was the seat of the arbitration. Then you have to see that was this country a party to the Geneva Convention or the New York Convention. There are 172 countries that are parties to the New York Convention. So most likely it will be the New York Convention country. If it is parties to both, then use the New York Convention. Okay. And then start with section 44. You will see in 44 that you have to basically have an agreement in writing, which to which the New York Convention applies, and it has to be a territory where there is a reciprocal provision and a notification by the central government, by the Indian government. Okay, so it is not to say that just because there are 172 countries that are parties to the New York Convention, you can take an award from any one of those 172 countries and bring it to India for enforcement. No. There are only 48 countries, 49 countries, and I would again request the audience to check for the correct notifications, because this obviously the list can be expanded in future. But there are 49 countries which the Indian government has notified for the purposes of Section 44 of the Indian Arbitration Act, and you can only bring an award from those countries for enforcement in India under Part 2. Okay, but most of your countries, like you name it, like Singapore and UK, US, Switzerland, France, all these countries are covered. China's covered, Hong Kong. So you typically you will be able to bring those awards, but it's important to do that preliminary check. Okay, so 44 is your starting point. And then obviously under 47, very importantly, the evidence is listed out that you will need an original copy or a duly authenticated copy, the original award or a duly authenticated copy of it. You need the original agreement for arbitration or a duly certified copy, and any other evidence that is necessary to prove that the award is a foreign award. And you will basically put all of that into your enforcement petition and try and enforce it under Part 2 of the Arbitration Act. So these are your procedural requirements, and your substantive requirements were in 44, like I mentioned.
Very well, ma'am. Now, going ahead with our next question, does mere filing of a Section 34 application for setting aside of an arbitral award before appropriate court act as an automatic stay on the enforcement of the said award?
So I did cover that in
Yes,
my
you did
previous sort of thing. So I think it does not,
does not.
except for that now one exception that the 2021 amendment has introduced, where fraud or corruption is proved on a prima facie basis in the making of the award. So that is the only limited thing where there's an unconditional stay. But you have to still apply for a stay. So the whole concept of automatic stay is gone. Okay.
So the whole concept of, to all the viewers who are watching, the whole concept of automatic stay is gone. Mere filing of a Section 34 application does not result in an automatic stay on enforcement of the said award. There has to be an explicit order passed by the appropriate court for granting of stay. Now, I'm going ahead with the next question. Is execution of a decree under the Civil Procedure Code the same as enforcement of an award under the Arbitration Act?
So basically under 36, It says that an award will be enforced in accordance with the provisions of the CPC in the same manner as if it were a decree of the court. So there is a decision of First Day Lawson which says you don't need to file like two petitions, one for enforcement and one for execution. You can have a combined petition, and the whole idea is that once the court decides to enforce the award, under the act itself, section 36(1) clearly says that it will be executed as if it was a decree. So your principles of CPC under Order 21 will come into play. And that's how it is going to be executed against the assets, either by sale or attachment, depending on movable, immovable assets. So that is how it is going to be executed.
Perfect. Now, ma'am, lastly, and this is my personal favorite question, you're undoubtedly one of the most sought after lawyers in the field of arbitration. So, who was your mentor, if at all you had any, and any particular books that you would recommend to all the lawyers, law students, watching this segment? And lastly, what would be your piece of advice to all the young lawyers and law students watching this session?
Well, I think in terms of mentors, I've had too many. I think I've been very fortunate in my career to have learned from amazing professors in GLC, and also right from senior counsels that I worked with, senior partners that I worked with. They have all been amazing in terms of teaching and consciously, subconsciously. It's been a great learning experience. So I consider too many people as my mentors, and I am very grateful to each one of them. As far as like the learning is concerned, I think it's very important for all students to know that it really never ceases. Um, and you can never ever be confident that you know it all. You have to be in this constant attempt to learn. Even if you may have read a judgment many times, and trust me, if you read it once again in the context of another case, you may really find a new interpretation to a paragraph that you may have read 5 times already in the past. So it's important to always be in that ready to learn state of mind, as opposed to getting into this space where you feel like you know it all or you know enough. And that I think is critical. And in terms of just the material also, there is no better place than to be acquainted with the Bare Act as the first primary source of the law. And very few people really do that nowadays. They tend to just immediately jump onto Manupatra and just to like, Google the key phrases, and then they start reading judgments without really understanding what the bare provision says. So my starting point, and not just on the Arbitration Act, in general, any law, your first primary contact has to be with the Bare Act. After the Bare Act, then you can supplement it. And again, I think the supplement should be the judgments of the Supreme Court, as opposed to text and commentary written by authors. Of course, that's important too, and you can read that as well. But I think it is first important to see what the court is laying down as the law in relation to a particular judgment. So at least for arbitration, I would encourage students to at least get acquainted with some of the decisions, just see what Balco says. And when you will read the landmark decisions, fortunately, a lot of them give you a historical background as well. So there is a whole section in the Balco decision which will tell you how the Arbitration Act has evolved over the years. What are the important judgments? So when you're reading a 2012 judgment, you know what has happened till then by reading that one judgment. You're reading Vidya Dholia, you know Vidya Dholia has captured all the previous decisions from Booz Allen already. So pick and choose the landmark decisions, and you will realize that your knowledge automatically increases manifold when you have read through the discussions in those judgments over the years of the previous judgments as well, and then obviously what has been laid down there. And that will also get you into the habit of reading the new judgments that keep coming out, because arbitration is an ever-growing field, and there's just so much discussion happening, and there's just so much of progress happening in the space. Even from the Supreme Court, the number of progressive decisions that have come out of the Supreme Court is something that we should be very proud of, as far as the arbitration space is concerned in the last decade. So important for students to sort of be in the practice of reading Supreme Court decisions. I think that is very important.
Very well then, ma'am. It was a perfect webinar. I think we were treated to the finest exposition that I've heard in the law of
I
arbitral.
have honestly just been able to
A
scratch
great
the
time.
surface, Jay. I know that we've been under a time constraint, and
Yes.
the topic that I was dealing with, in fact, I was trying to touch upon multiple topics. Really, each one of them can take hours and hours to explain. So if I was rushed, then I apologize. But I would still recommend that students end up reading a lot more than just the very basic that I have spoken about. But there is a lot to read and learn in this space, and it's all very interesting. So I do hope that that should continue for each one of you.
So grateful to you, ma'am, for taking out time and doing this session for us. Really means a lot to me and my entire team. To all the viewers who are watching, our email is mentioned on the channel. In case if you have any queries, and I don't think you must be left with any queries by now, because all your queries must have already been answered brilliantly and beautifully by ma'am by now. So our email is mentioned. Feel free to write to us. We'll be more than happy to forward the same to our amicus. Thank you so much, ma'am. As parting words, anything that you wish to say before we wrap this up?
Just keep up with the good work, Jay, and good luck. Good luck to all the students and young practitioners. Thank you so much.
Thank you so much, ma'am. It's goodbye for now. Thank you.
Thank you.